Good afternoon, Assalamu alaikum. Ladies and gentlemen, it's my pleasure, and I say that sincerely, to be here before you to discuss this new law, because it was only 3 months ago that I was standing in this very same spot asking for the new law to be adopted. And I have to give credit and congratulate many of you in the room who are responsible for this law reaching the Gazette and coming into force, I believe, tomorrow. Just a coincidence, it's my birthday as well, but anyway. It's been an effort. It's been a Herculean task, but it's going to be worth it. I'm going to explain why. By way of background, many of you in the room are familiar with arbitration, how it is the default process for resolving disputes, and some of you in the room are also familiar with how arbitration goes wrong, because the clause hasn't been drafted properly, because the applicable law hasn't been selected clearly, because the seat of the arbitration is a rather slippery place, where if you end up before the local courts, it can take forever to achieve clarity as to whether or not an arbitrator ought to be disqualified, whether or not you can obtain measures from the court, and ultimately enforcement. Now, these are not issues that are confined to what are often described as the developing jurisdictions. I can tell you that I was in court on Friday of last week in England, the commercial court, to seek to enforce a very substantial arbitral award in circumstances where the other party, having been unhappy about the award delivered by a very well-known arbitrator in France, decided to issue proceedings simultaneously in 3 other jurisdictions. And that award is now waiting enforcement for 1.5 years. The court had to grapple with an issue that's never been dealt before. I'm not going to tell you what the case is, but it's actually a very important case. And our friends in the legal journals will no doubt be looking at this as being an illustration, possibly, of how people can even derail enforcement of arbitration in a jurisdiction as developed as England and Wales, if they are tactically astute enough. So why is it important? Well, background. In London we have the LCIA. The LCIA has seen what some may see as an interesting reduction in the number of arbitrations issued from 2015 to 2016 of the region of 10%. The ICC statistics comparing 2015 to 2016, approximately 1,000 arbitrations commenced in 2016, almost a 20% increase in that period of 2 years. Singapore International Arbitration Centre, which has been a success that's familiar to many of you, has seen almost a 40% increase in the number of arbitrations commenced, in the Singapore Arbitration Centre since 2014. I understand that the Qatar Chamber of Commerce, according to comments made by the Qatar International Centre for Commercial Arbitration, had 275 arbitrations in 2015. A significant number of those were all above the value of 1 billion Qatari riyals. And that's a substantial number. The benefits for all of you in the room and for Qatar of having sound legal mechanisms for dispute resolution should be obvious. Because if parties can't obtain effective dispute resolution in the courts in Qatar, they'll go somewhere else. And if they can't arbitrate effectively in Qatar, they'll go somewhere else. That is the reason why we have a proliferation of arbitral centres. There's not a country that doesn't want to establish an arbitration centre soon. There are success stories, and there are also stories that are less spoken of because they've been failures. And why? What I want to do is explain to you what the essential ingredients are for an arbitration seat to flourish, what is happening in Qatar as a result of the new law, and what more needs to be done. Because there's always more to be done. No system is perfect, and anybody who tells you it is utterly misconceived. The law that we have is a massive improvement on the law of 1990. This is not to criticise the drafters of the 1990 law, We're not here to criticise. What we're here to do is exchange constructive views so that we can make sure that what's happened and what's on the statute book now is utilised and is the subject of use by all of us in the most effective way possible. So what makes a good arbitration seat? What I described as the 3 L's. It's a legal framework, legal community, and logistics. And what are the elements that parties, time and time again, say influence their choice of the seat? Neutrality, internationalism, reputation, the ability of that jurisdiction to recognise arbitral awards, and the previous experience of the institutions in that jurisdiction. So the institutional rules have to meet the needs of the parties. They have to be equivalent to international standards. Appointment of arbitrators, challenge of arbitrators. They are increasingly providing facility for emergency arbitrators, issuing what are called provisional measures, reflected in the law. You have many of the institutions responding to changes. Consolidation of arbitration proceedings, where you have lots of different claims arising, particularly in the construction context. Same parties, suite of contracts. So one of the cases that I've just dealt with had 6 contracts between the same parties, and in theory they could have all been dealt with separately. But because the institution provided for consolidation, they were all dealt with by one arbitrator. And we can see how important arbitration is because every single arbitral institution has been looking at its rules on a regular basis, whether it's the Singapore International Arbitration Centre, whether it's ICC or LCIA. They all want to improve, and there are 2 areas in which they're particularly concerned. Expedition, speeding the process, and cost, reducing cost. Almost 50% of arbitrations involve a sole arbitrator, and that's an important point for you to bear in mind. There's this sense that if you have 3 arbitrators, it's better than 1. And when you have states, it's not uncommon to have 7 or 9 arbitrators. And guess what happens? Those cases take years. Some of you may be aware of ICSID arbitrations. These involve states and investors. Whereas the average time for an ICC arbitration or an LCI arbitration varies between 20 to 24 months, according to recently published statistics. An ICSID arbitration takes around 4 years. Compare that with court process. That's still quicker than many courts, from start to finish. Now, whilst you're engaged in arbitration, having chosen arbitration in your contract right at the outset, having identified the governing law, having identified the seat, which hopefully from tomorrow will be Qatar more than it used to be, you then have to ask yourself, well, what is the relationship that we want ideally with the local courts? Well, the local court shouldn't be controlling the arbitration, it should be supporting the arbitration. And I'm pleased to say that the Law No. 2 of 2017 reflects that objective. So one hopes that whether it's the Qatar court, although it's wrong to say Qatar court and the international court because they're both courts. They're both the courts of Qatar, and that, if there was any doubt, that's now clear from this, the Law No. 2 of 2017. It's to be hoped that we will have all of the courts and the institutions operating in harmony. And then we get to the national law, where we've got a checklist as to what the national law should do. Well, ideally, it ought to be based on the UNCITRAL model law, and what I said last time, and I say again, there are plenty of examples I could point to, but I shan't mention, where whenever an observation is made, the answer is, well, it's based on the model law. We did a little bit of tinkering with it. Unfortunately, the tinkering was destructive. And just to say a legal system has adopted the model law is not enough. It's the culture, the mindset. And the last bullet point is the most important. Government support is crucial. A successful seat requires constant consideration, recognizing that not only is it important for your own business community, it's also important in terms of your reputation internationally. There are places that have achieved a very strong reputation as dispute resolution centres, whereas if you actually scratch the surface, you might ask questions about what's going on within that jurisdiction, again, without identifying them, but they've succeeded because they've put dispute resolution, commercial dispute resolution, up at the forefront. Not just to provide for commercial parties coming in and domestic commercial parties to resolve disputes effectively, but also because it sends out a very strong message. And what do we need from the national courts? And here what I'm going to say is, whether you're talking about the Qatar court, which sits within the framework of the Court of Cassation, or the international court, these are both the national courts. And that's a point that we have to make clear again and again. And what the law No. 2, 2017 has done is given parties a choice. Do you want to choose a judge who is familiar with Qatar law, with Qatar procedure, but is on the same footing jurisdictionally as the international judge, who is familiar with international business, commercial transactions, international procedure? What my expectation is that both of them will adopt a similar approach when it comes to arbitration, which is support, not intervention. But what do we need from the judges? Familiarity with arbitration matters. Not suspicion, familiarity. Respect for the arbitration process. Not suspicion. We know that there are some jurisdictions where arbitration is seen as being suspicious. I can tell you in Italy, which is one of the major commercial centres, it's only now, as of this year, I was speaking at an event where I was responding to the chairman of a committee set up by the Italian government to reform Italian law. The Italian courts are very suspicious of arbitration. Why? Because in the civil law jurisdictions, there is a philosophical point, namely, justice is to be delivered by the courts, not by private institutions sitting in nice rooms, but judges, and judges must be able to scrutinise the delivery of justice, be responsible for it. That's the reason why. So when you look at courts passing judgment in the arbitral context, just think about what the judge is looking at this for. He's looking at it through the prism of responsibility, not necessarily interference. And it's important to do that. The judges obviously have to be highly skilled. And goes without saying, perhaps not, they must be respected. I can tell you, even in England, there are some judges who are more respected than others. They have to be neutral. They have to be independent. Extremely important. Even the slightest perception of lack of neutrality and independence will mean that parties will not use a jurisdiction if they have a choice. Of course, we need experienced legal personnel, from the court staff to translators, experts. We have to have institutions which look at the part of 21st century dispute resolution hubs. We know that the Qatar International Court is going to be moving to the very impressive facilities in Musharraf, which not only are environmentally friendly, but use architecture which is going to be the envy of many. I'm sure that the officers here of the Qatar International Court would be more than happy for all of us to go off and visit what is still a building site but rapidly achieving completion. We've got to make sure that arbitration is expeditious. So the institutions and the courts that are supervising arbitration, the institutions that are operating the arbitration must have a mind to expedition. I've given you the deadlines for the ICC and the LCIA, 20 months, 24 months. Those of you who are familiar with the court process here in Qatar know whether 20 months from start to finish is realistic for court process. I can tell you in England, from start to finish, from starting the case in the commercial court to ending up in what generally tends to be the last place, the Court of Appeal, 20 months is not unrealistic. Facilities. We're presently in facilities which are excellent, which would be the envy of many people. But these facilities are going to be improved yet further when the International Court moves to Musharraf. Who will occupy these facilities? I'm sure there are going to be plenty of people wanting to occupy these facilities because they're excellent. I don't know whether there's going to be a sealed bids process or some other process, but watch this space. Now, the rest of it, logistics, it's all here. What was missing? The legal framework, we've now got this, and ensuring that the legal community, not just the lawyers, but the judges, are beyond reproach in terms of expertise, independence. I'm not saying that they're susceptible to criticism at the moment, but we've got to make sure that there's absolutely no question of there being any criticism of any judges, or of the facilities, even. So what's the new law about? You've got it on your chairs. It's a nice glossy handout. This is the approved translation. Hopefully we'll all be guided by this. This is an approved translation which succinctly identifies the core provisions. 38 articles, comes into effect tomorrow. Christopher Grant's giving you an overview of them. I'm not going to go through the provisions article by article. What I can tell you at this point is, and I'm very pleased to announce this, that as a result of the initiative of the Qatar International Centre, there is going to be established a user committee. We're going to convene that user committee within 3 or 4 weeks, and that also sends out the strongest signal possible that Qatar is not only open for business as far as arbitration is concerned, but it wants to ensure that everybody, all of the stakeholders are on board. Whether it's the national courts, whether it's the lawyers, or the ministries. So any of you who are interested in participating in the user committee, please make yourself known at the end of this event. On your chairs, you have a 2-page bullet point handout, which is the culmination of my experience. It's headed do's and don'ts. Some of you, when you go through that, and I know there are several of you in the room here, will say, yeah, perhaps, yes, we shouldn't have done that, or if only we'd done that. These are common problems that occur in arbitration, and therefore, I suggest, useful for you to bear in mind. I said I'm not going to go through each of the provisions in turn. There is a handout which we've prepared, 6 pages, which analyses the key provisions, and we're happy to give you a copy. We'll email it to you, or we'll give it to Christopher Grant. The International Court can email it to you, or so you can read the law and look at what we've tried to do by way of summary. Article 2 identifies the scope of the law. It provides a definition of an international commercial arbitration, also a commercial agreement. Article 7 stipulates the requirement for an arbitration agreement to be in writing. Exchange of emails could constitute an arbitral agreement being in writing. Appointment of arbitrators. There is a ministry registry which people can apply to be a part of, but equally, you're free to appoint arbitrators from the general populace at large, subject to there not being some disqualifying features. I wouldn't imagine that anybody here would want to appoint a convicted criminal, but that has happened in the past, so there's always a first time. And Article 11 seeks to protect you against your own worst excesses by disqualifying convicted criminals. You have, at Articles 12 and 13, the requirement of independence and impartiality of arbitrators. This is a reflection of international standards. There's no procedure set out in the article itself, but there is a finite timeline. Liability of arbitrators. This is an interesting point. Bad faith, collusion, or gross negligence are the fundamental requirements for an arbitrator to be held liable civilly. Contrast that with the UAE provision, and I'm not here suggesting that this is not to berate or criticise the UAE position, I'm just telling you that this is the position. Article 275 of the UAE Penal Code, as it seemed to apply to arbitrators now, could potentially expose arbitrators to criminal liability for lack of independence and impartiality. And whether it's been misunderstood or understood properly by the international community is a separate matter. I'm just mentioning it to you, because Qatar law doesn't provide for criminal liability in a similar way, so there's less concern, well-founded or otherwise, on the part of arbitrators sitting in Qatar that they might be hauled before the courts, criminal courts. The conduct of the arbitration. Provisional and interim measures at the behest of the tribunal or the competent court, Articles 9 and 17. Article 24 provides for oral hearings. And here I should point out that the arbitral award is to be kept confidential unless the parties agree otherwise. As Christopher Grant mentioned, it's probably wise for you in your arbitral agreement to stipulate confidentiality of the proceedings if that's what you want. Not all arbitral institutions and arbitral rules provide an express confidentiality undertaking. In English law, it's implied. Article 26 allows for tribunal-appointed experts. This is going to be an interesting provision. I'm supposed to be talking about something in the context of investor-state arbitration, where we have claims for tens of billions of dollars. And sometimes what happens is arbitrators decide to do the maths themselves without recourse to an expert. And when you've got sums involved of $30, $40 billion, GCE, GCSE or A-level maths or even a degree in mathematics might not necessarily suffice to shave off $50 billion from a claim. That is what happened in a case brought by UCOS against the Russian Federation, which is going through the Dutch courts on appeal. Enforcement challenges. The delivery of the award is provided for in Article 31. The requirements or the grounds for annulment, Article 33. Recognition, enforcement, Article 35. The grounds, arbitrability, public policy. Arbitrability, public policy are very important grounds. And again, for those of you who know the framework of the New York Convention of 1958, what we have is a balance between court jurisdiction and providing court jurisdiction to support arbitration and allowing parties to conduct proceedings privately. There are some limits beyond which parties cannot arbitrate. So, criminal matters, you can't arbitrate. You can't go off and have a fight with somebody and say, well, let's arbitrate this as opposed to you going to the courts, because the state has an interest in ensuring that the law is upheld in those kinds of matters. Interestingly, in England now we're moving in the direction of allowing family disputes to be arbitrated, which there are probably lots of ex-husbands who will welcome that, because being hauled before the English courts and being described as having behaved improperly is probably not something that many ex-husbands want to suffer the indignity of, rightly or wrongly.
And ex-wives.
And ex-wives, yes. Absolutely, you're absolutely right to point that out. We also have claims being brought by gentlemen who want access to their wives' assets. Not to the same extent, it's a smaller fraction, but yes, quite right to point that out. Probably about 5%. So, oversight. You've got the competent court, Christopher Grant's identified that, and then you've got the involvement of the ministry. There are two elements in which the ministry is involved. We can discuss that later, but my understanding is that this is obviously by way of protection. You've got the ministry registry, you can go off the registry if you want to, and you've got the furnishing of the award within 2 weeks of delivery of the award to the ministry. It's not stipulated in the law that failure to deliver the award to the ministry will somehow have some sort of procedural or substantive effect. And the rationale, as I understand it, and no doubt in due course the ministry will issue some guidance, is that this is to enable the rest of us to receive statistics in the same way that you have statistics from SIAC and LCIA and ICC. So the ministry is probably best placed, if we've got different institutions operating in Qatar, to be able to collate the information and tell us how many arbitrations commence, what's the value, what's the cost award, because that's the kind of detail that the award has to contain. Gender. Gender is extremely important, picking up on the point that Mr. Grant made, lest there be any suggestion that what I've just said was inappropriate from a gender perspective. This is a matter of great concern. Gender imbalance in the appointment of arbitrators. And what we're seeing is the institutions themselves are now reaching the point where 25% or thereabouts of institution-appointed arbitrators are female. There's still a very big imbalance geographically. That's something that has to be addressed, and making a place like Qatar a strong centre for arbitration is going to help address that geographical, cultural imbalance, I'm sure, in the years to come. So the involvement of the ministry, we can discuss it, but it seems to be explicable on that basis, and no doubt the minister will provide us with some confirmation of that in due course. The next steps. Sounds simple in theory, and as we would say, inshallah, will be achieved. Because having waited 17 years for a new law, I would counsel caution, step by step. So what do we need to do first? We need to ensure that the judges who are dealing with arbitration matters are from a pool, identifiable, a bench even, which is conversant with arbitration. So specialist judges, specialist arbitrators, we've got to enhance the capability of arbitral institutions, we've got to build confidence in the end user community, we've got to have more contracts with Qatar as a seat, and the last point, which is the guidance from the MOJ. Thank you.